Ms. LaQuasta.
May it please the Court, I'm Wendy LaQuasta. I'm here representing claimant Charles Weaver in this case. I'd like to reserve 3 minutes for rebuttal. I'm going to start off with a little unusual request. I know that I'm here to answer the questions that y'all have, but I've prepared some material that I think would be helpful to y'all in deciding this case and understanding claimant's theory, so I just ask your indulgence while I get through a little bit of material. I think that there's some critical facts that you need to consider in this case. Number one is that claimant was legitimately injured in a compensable accident. He injured his dominant right wrist. It was diagnosed as a fracture and carpal tunnel, treated as such, but it turned out to be more. There was a torn ligament and tendonitis, and that required surgery. And about a year after the accident, he had the surgery, a fusion with a bone graft, and that failed. The bone rejected the pin, and it actually protruded from his skin. There was a second surgery that had to be performed, and that was performed about 3 years, a little less than 3 years after the original accident. So we've had 3 years of daily pain that's chronic. In the midst of all this medical thing that's going on, there's other stuff going on in this case. And, claimant lost his job with MBM. The JCC found that he could have legitimately interpret what was said to him to be that he was fired because he couldn't perform the job duties anymore because of his injury. He did get another job, it didn't pay as much, and he had financial difficulties. I'm not going to make any excuses for claimant, but the fact of the matter is he's a father of 4, his wife is disabled, he had financial difficulties when he lost his job at MBM. So we've got a bankruptcy, we've got a loss of a house, and we have the credit card fraud of which both he and his wife were convicted. In the midst of all this, he develops psychiatric problems and he needs treatment. So he files a petition for benefits for psychiatric care in September of 2002. This is before he's actually arrested on the credit card fraud. So that's a factual background. I think that's important to consider here. Our first issue is an equal protection claim. We allege that there's a classification scheme that's created by Section 44105 and 4409, and it's that classification scheme that violates equal protection. We know the rational basis test applies, so if the classification scheme rationally advances a legitimate government objective, we're going to be affirmed. Here, the classification scheme is that under 44105, we have a situation where the statute calls for insurers to report things that they think are insurance fraud.
Where would we look for? I know you wanted to get through some of your stuff, but since you concede up front that it's rational basis, as we've previously held with regard to a due process claim under this, where would we look to find a Florida Supreme Court case that sets aside a statute based upon rational basis?
Maybe
certainly not in the law library, right?
I know that it's a hard test to pass, but I think that when you look at the unfairness that has developed with this classification scheme, I think that that's what you really have to look at. It's become an arbitrary scheme, and that's because of the amendments that have happened. Since with all the amendments, 44105 originally, says has to go to the Bureau. Bureau's a law enforcement agency. They conduct an investigation. If they decide there's enough evidence, they turn it over to a prosecuting or a licensing authority for them to delve into. If there's not, they dismiss their case. Under 44009-4, as it currently exists, JCCs also have the authority to determine fraud. So you've got two different schemes that are going on here. You've got a scheme that applies to ECs, they go to the Bureau. You've got a scheme that applies to claimants, they go to JCCs. So it's these two different things that are going on at the same time that we submit creates the classification that's now arbitrary. And the arbitrariness is found by the disparate procedural due process.
Aren't there two entirely different purposes being served by these two different procedures? Claimants are seeking benefits from an employer carrier. And under the statute, the JCC can determine whether they are committing fraud and trying to get benefits. Now, the EC is not looking for benefits under the statute. But if they commit a fraud, two things can happen. The JCC can determine that they committed fraud and make them pay the benefits, the fraud is not a good defense. Or they can be prosecuted civilly or criminally over here on the other side for their defalcations under the law. I don't understand why, in your equal protection argument, they have to be channeled through the same agency.
Well, claimant can also be subject to criminal prosecution too, and as the EC's attorney says in their brief, this is actually their kind of civil action is what's going on here. So both sides can be punished in the same way. So the question is why aren't they subject to the same kind of procedures? And that's really what it all boils down to. We're just asking for the same procedures to be applied to claimants as ECs. And that's not currently being done. And that's the problem with it. There's an EC has a separate proceeding before the Bureau, which does an investigation. They can pursue that in that forum. Claimants faced in their claim proceeding to have to defend against this fraud allegation plus prove their claim. If the JCC finds against them, there's not another administrative hearing after that. There's just the appeal to y'all. And so that's different. That's a different procedure. And there's also, I attached some things to my document, our second basis on equal protection, and then I'm going to get out of it because I understand you may or may not go for it.
There's a different remedy and a different claim. They're two entirely different concepts.
Well, and I appreciate that you could see it that way, but I think that there's a great deal of unfairness that's going on with fraud right now, and I think that my second point under the equal protection has to do with the disproportionate amount of proliferation of fraud claims against claimants. There are 20 or 25% of the losses in workers' compensation fraud, and yet a disproportionate amount of the resources and litigation and calls and complaints are aimed at them.
Wouldn't that, though, be subject to an as-applied challenge on access to courts grounds rather than equal protection on its face?
I'd love to have made an as-applied argument here, but I didn't have one below, and I can't make it now.
I know you can't, but that's why. But what you're saying is not really in the record. I mean, we may intuitively feel like more claimants are getting caught in this than carriers, but I don't know that. That's why I'm just suggesting that if that really is the claim, it seems to me like it would have to be made with a factual record.
I think that the public record, the state, I've attached staff analysis on what's going on and articles that are available. I think this is in common knowledge, and you all can understand that that's what's going on. I think you've probably seen it in your appeals, that there's a lot of cases that are coming up on fraud, and they have been coming up. But I know my time's limited, and so I want to go on to the second issue because I think you probably have some questions about that. Our theory is that the JCC didn't have jurisdiction to make a finding about fraud here because there's a conflict in the statute. So under 440-105, it creates this procedure that sends claims to the Bureau of Workers' Compensation Fraud, and under 44094, the JCC gets to decide whether there's fraud. So we've once again got two schemes, and black letter law says that when you got two statutes that deal with the same thing and they're in conflict, the more specific statute's going to control. We maintain that 440-105 is that statute. It defines workers' compensation. It says when somebody suspects there's fraud, goes to the Bureau. Bureau gets to investigate. And so we maintain that that wasn't done in this case, and since it wasn't done in this case, JCC did not have authority to make a ruling on the fraud. And, I'll say on this, comp is a creature of statute. JCCs have the powers that the statutes give them, and, there's a conflict here, and when you resolve that conflict, it just didn't have authority to be able to make that ruling. And I think that this case is kind of like it's a little bit like the Polston and the Simpson cases that I cited in my brief. The third issue that we have is, whether there's competent substantial evidence that accords with reason and logic to support a finding of fraud by preponderance of the evidence. I know this is a hard issue for an appellant to make, but I just want you to look at this case and the totality of everything that's going on. The best analogy I can come up with is for claimant, this is the perfect storm. He's got a legitimate injury, chronic pain. He needs psychiatric care. We got an EC, pecuniary interest for finding a fraud, and they get to wear their prosecutorial hat because of the procedures that are that are allowed. And then we get a conflict on major contributing cause on the psych. And so we enter the expert medical advisor, Dr. Gutman. And, you know, he's got a process where he interviews patients that allows their wives to come in, and he collects information from the whole family about what's going on. And we can't tell in this record who he got that information from. We know that he's described Climate as a quiet man, and that his wife chimed in and gave answers. So we don't really know what the source of the information is that Dr. Gutman has. We also know that he is a forensic psychologist. He says, he admits, I didn't ask the questions that I ask when I go and interview inmates in the jail. I don't have all the details. And then when he's told all the details, you know, during cross-examination, you know, EC's attorney brought it all out. Hey, did you know this guy got 10 years probation? Do you know 10 grand worth of restitution? Do you know his wife was involved? Do you know how many credit card transactions there were there? I mean, he battered him, and Dr. Gutman said, no, I don't know that stuff. But at the end of the day, Dr. Gutman said, I need another 15 to 30 minutes to evaluate this and see whether this new information that you're giving me today would change my opinion. That's what I need. So that's kind of where we're at. And then we have the JCC. He's been involved in a process that has allowed him to see reams of prejudicial information as to the credit card fraud. I mean, all the transactions are there on printouts. There's the judgment. There's the restitution order. It's all there. Plus, we have what amounts to be volumes in the record of testimony solely about the credit card criminal act. I mean, his wife actually said, I feel like I'm being retried on this crime during her deposition. So there's all this prejudicial material put forward to the JCC. So when Dr. Gutman testifies, he doesn't hear that I need that 15 or 30 minutes to be able to reevaluate to see if this is going to change my opinion. He just says, I heard enough. This is fraud. I'm denying benefits. So our question to you is Dr. Gutman's testimony competent substantial evidence that accords with reason and logic under these circumstances to support a finding of fraud by a preponderance of the evidence? Or is it a situation where an unfair process allowed a lot of information to get to the JCC so that he jumped the gun and made a finding of fraud based upon the prejudicial information he'd been exposed to? I see that I'm in my rebuttal time, and I'm done.
Mr. Oxford.
Thank you, Your Honor. May it please the Court, Lamar Oxford for the employer and its workers' comp carrier in this case. As this Court can imagine, I am certain that when Mr. Weaver slipped and fell at work in August of 2000, neither he nor his employer nor the comp carrier, when they were notified of it, had any idea that this little slip and fall, important to Mr. Weaver, but an everyday occurrence, would become the focus of an argument that is earth-shaking. The claimant's bar has picked this case out, and they're going to pick a lot of cases out to ask this Court to throw out the entire anti-fraud provisions of Chapter 440. And there's no question that's what's going on here. And Ms. LaQuasto has done one heck of a job in bringing the argument based on very little factual basis for it. I think Judge Barfield hit the nail on the head on one of our key arguments, and that is there's no discrimination in this classification scheme because the folks up the street in the legislature created two different anti-fraud processes. The more general one under 440.105 says that if anybody, the employee, a nurse, the employer, an adjuster, a doctor, if anybody in the entire process commits fraud, if the employee slips and falls and the employer says, that's not comp, or if the company nurse turns to an injured employee and says, you can't file a claim for comp under that, if an adjuster says it, then they can be reported to the Bureau, they can be investigated, and they can possibly be turned over to the state attorney's office for insurance fraud, indictment, and possible conviction. But if an injured employee pursues benefits, if he files the papers and says, I want something, that I'm entitled to and I'm not receiving, then the legislature, in its wisdom, also found that a judge can be an independent arbiter of that. Now, the claimant's reply brief tries to backtrack from all the inference and innuendo in the initial brief, but there's no question that there's an argument here that judges can't be independent with regard to deciding whether an employer carrier can prove its fraud defense or not. That's an absolutely independent forum. The claimant is given notice by the employer carrier that we believe you committed fraud in your pursuit of these claims, and we're going to try to prove it. The claimant and his attorney then have ample time to disprove it. It's no kangaroo court, and the judge sits there as an independent arbiter and hears the evidence from both sides as to whether or not fraud was committed that was material to the claim for benefits. And if he decides that it was committed and denies benefits, then many claimants come here and ask you to review that evidence and make that decision of whether it was material. I've stood here before and had to debate with this honorable court whether the particular fraud that everybody admits occurred was material to the particular claim that was being sought after. But that's not this case. In this case, the fraud is so prevalent, so open and obvious, perjury directly in front of the judge, insurance fraud in the form of a lie to both psychiatrists, that the argument has become much more general, that the whole process is not constitutional. And it's not constitutional because somehow the two different processes of anybody reporting fraud and it going through the Bureau of Workers' Compensation Fraud, or the employer claiming that fraud was committed and arguing that as a defense to the judge of compensation claims, there's no rational basis for those two different processes. And we respectfully submit there is a rational basis for both, as Judge Barfield's question certainly implied, and that ultimately this argument needs to be brought up the street to the legislature. But is there a legitimate governmental objective? Well, I stand here wrapped in the flag, let's say, because I'm here on behalf of everybody who's harmed by insurance fraud, which happens every day. The fact that claimants, and this isn't even the record, but Ms. LaQuasto brought it up, the fact that claimants are found more guilty of fraud than anybody else is no one's fault than those people who commit proven fraud. They're looking for something, they might exaggerate, they might lie, not many do, but when they do, the employer has the right to come in and prove it to get those benefits denied. And that is exactly what happened here. This gentleman told the judge that all his temporary partial disability and his need for psychiatric care was due to a wrist injury he'd suffered at least 3 years earlier, possibly 4 by the time of the hearing. He told both psychiatrists that his need for psychiatric care was caused by a wrist injury, and he didn't tell them that he had committed $13,000 worth of credit card fraud, that he and his wife had both been indicted for conspiracy because they were both employed at the place where they committed the credit card fraud, dozens of incidences, most importantly, that they had pled guilty to it. And then he came before the judge and said, well, actually, my wife didn't know anything about it. I apologize for using a trite phrase, but this really was one of those poster childs for fraud. No question about it. A bad case to bring up on appeal, except for this generalized constitutional argument. One of the arguments is that 440.105 is more specific, 440.09 more general. The specific should rule over the general, and you should throw out all of 440.09, which allows judges to decide a fraud defense. Well, I respectfully submit that 440.09 is more specific because it only has to do with those cases where a claimant is seeking benefits to go before a judge and the employer believes he's committed fraud in the pursuit. Whereas 105 has to do with any fraud committed by anyone in the system, and the Bureau is set up to investigate that. So with regard to both the first 2 points on appeal, we respectfully submit that there is a rational basis for what the legislature created. The entire system is a creature of statute, and the legislature had obviously legitimate governmental objectives, public purposes in enacting the anti-fraud provisions. So the judge does have jurisdiction under 440.09 to do exactly what he did here. The final point on Dr. Gutman, keep in mind that Dr. Gutman asked both spouses to be there to give him the history. So it's not as if, as implied by the claimant's counsel, that the wife may have been telling Dr. Gutman one story and the husband another, and Dr. Gutman was confused. They were together. If the wife told Dr. Gutman something wrong, the husband could have corrected her. The bottom line, which Dr. Gutman admitted, was that all he was told essentially was that this need for psychiatric care was due to this wrist injury, and he was told that what had happened was a one-time offense with regard to the credit card fraud, and in fact they had been falsely accused, and in fact their employer had given them permission to use the company credit card for all these personal expenses. They told Dr. Gutman that after they had pled guilty to the exact opposite. Clearly fraudulent material. So this is the wrong case, but even if it was the right case, the statutes aren't unconstitutional. Insurance fraud is important to everybody. Legislature recognized that, enacted some relatively tough processes within workers' comp. But a claimant has every right to go in front of a judge or the Bureau or anybody who's accused of it and prove that they weren't guilty of fraud. So it's fair, there's equal protection, and we would respectfully submit that the order was right as applied in this case, and that the appeal on constitutionality itself should be denied. Thank you very much.
I just have need to respond to a few things. I'm not asking you to throw out the entire fraud provisions of 440. I'm just asking you to apply them equally to claimants and ECs. And I think that you can easily throw out the fraud finding here based on like a CSE. I'm also not attacking the JCCs and saying they're incompetent or they're not independent. I'm just pointing out that the Bureau is a law enforcement agency.
What would we do, though? I mean, would we excise the authority of the judge of compensation claims under 44105?
Well, I think that under the second argument, I think that you can find that unless it goes to the Bureau, that authority doesn't kick in, which is kind of how the Polston and the Simpson case came. There's a contingency that allows the JCC to make that finding. So I think it can be squared with those. I think that the big difference that I want to make about the Bureau, the difference between the Bureau and the JCC is Bureau is law enforcement. They have investigative subpoena power. They take over and they do everything. And whereas here in the JCC realm, the person who actually gets to collect all the information against the claimant is the person who has the most to gain, and that's the EC, pecuniary interest. It used to be you only lost your benefits that were actually connected with the fraud, but we've ratcheted it up now so that you lose all benefits. So the person that's has the most to benefit from a finding of fraud is the person who presents all the evidence to the JCC. The JCC does not go out and subpoena anybody or get any extra information. And that's what I mean about the lack of independent investigation in terms of, I'm not attacking the JCC. I think the other thing that you need to understand in this case is, Mr. Weaver disclosed his crimes. He didn't deny that he committed this crime. He told everybody. And, we're making a decision based on, you've done a lot of criminal cases. You've seen them all. People enter pleas. They might not agree with what the charges are about that have been alleged against them. And that's certainly clear in this case that these people didn't agree that the charges that were set against them were actually true. They said that they ratcheted up the amount that the charges were to make it a felony. They said that the employer gave them permission and then revoked it. So there were disputes in the record about it. But in the end, they took their attorney's advice and entered a plea. I see I'm out of time. May May I wrap up?
Wrap it up,
But
yes, ma'am.
but they entered a plea because that was what was in their best interest. So, we're basing our decision on whether they perjured themselves or lied about things upon their subjective view of their guilt. And that's really what this case is all about. It's a finding of fraud based on subjective feeling of Mr. Weaver. So, we ask you here to reverse the order. Thank you very much.